Here's a comment from Charles, and Charles, as always, I appreciate your comments. So the question is, part I do not understand is how a party can go into court not owning the debt. So he's talking about a debt collector or a debt buyer here, claim they own the debt and get summary judgment under pretenses of fraud. This process reminds me of the FISA court fraud that the FBI has been exposed to doing. Lying to court, can't wait to see how that turns out. Well, the last part of that will be interesting to see what the court ends up doing, and obviously that's a totally different area. But are we going to do surveillance on citizens, and what's the basis for this? And that will be very interesting. I can speak to the civil side, and let me just speak in general about lawsuits, and then we'll kind of get into the debt collection lawsuit. So in general, if you file a lawsuit, then those are just your allegations in the complaint. But if the other side is served and they do not answer the complaint, then you seek default judgment. And most, not all, but most judges will say, well, I'm going to assume that since the other side did not answer, that they agree with everything that you said. And so you win if you're the person suing. Now, that makes some sense because the judges are trying to move the cases, and hey, if the other side doesn't bother to show up, why am I going to take much time to look at this? So now that would be true if you sued a debt collector or if a debt collector sues you. So that's one way. A debt collector could sue you. Maybe they truly do not own the debt, but if we don't answer, if we don't show up, then they win. Now, what Charles is talking about specifically is getting summary judgment. And in that situation, they're going to have to prove to the court that there do not appear to be any disputed, what are called material or important facts. And it's just clear that the debt collector is supposed to win. Well, the consumer is supposed to respond to that summary judgment, and you have to do it in the right way, at the right time, and the right format, and that's Rule 56, Federal Rules 56, Alabama Rules Civil Procedure 56. Most states it'll be Rule 56. So you could have a situation where the consumer just ignores Rule 56, says, and I've seen this where consumers say, I'm not going to respond to this because I don't believe in this summary judgment stuff. I want my day in court. Well, this is your day in court and you just lost it. So in that situation, the judge would say, well, the only evidence I have is from the debt collector. So what if the debt collector's lying? Well, the problem is if you get a judgment against you, it's really hard to then go sue that debt collector and say, well, they lied. Because now what the debt collector has done, it has sort of the credibility of a state court judgment. That judgment is there that says you, in fact, do owe this money. And so there's a doctrine that we can't really lose in state court and then go run to federal court and try to get the federal judge to undo the state court. And it's called the Rookerfeldman doctrine. And so this is an important concept, and I understand the frustration Charles is expressing here. I have the same thing. These guys come into court, they really don't have the proof, and they're just hoping the other side doesn't properly respond. But the deal is, there has to be finality of judgments. And what I mean by that is, we have to say, now the case is over. And everybody move on. Now, there are certain periods of time when you can ask the judge to reconsider something or to appeal. But once we're past all that, then the judgment is final. And this is very frustrating if, for example, a debt collector sues you and you say, well, I know I don't owe this money, so I'm not going to do anything. Somebody told me on the internet that all these judgments and lawsuits are bogus and I don't have to respond to it. Well, they may have sincerely told you that, but now you have a real live judgment against you. And if your time period is over, you cannot go back and challenge that. And the reason is, again, this finality of judgment. So let's take a different example. I represent you and I sue J.B. Hunt Trucking Company, and we get a judgment against them, whether it's a default judgment, whether it's summary judgment, whether it's a judgment after a trial. And then 6 months later, a year later, J.B. Hunt says, we think this big judgment you got against us is wrong, and we now have the proof that it's wrong. Well, it's too late, because otherwise no judgment would ever be final. And people would be coming back a year, 2 years, a decade later. No, I'm not talking about where we were not served, okay? I mean, I've gotten rid of judgments that are 15 plus years old when we haven't been properly served. But put that aside. When we've been served and we just lose, at some point that judgment has to be final. It's over. Think about it in sporting terms. A referee may make a bad decision. We certainly see that, whether it's college football, pro football, basketball, whatever it is. But once the game is over, it's done. You can't go back and change it. And everybody might agree, oh, this team should have won instead of that team. It doesn't matter. It's final. It's in there. So the key is, if we're being sued, we've got to defend ourselves. We cannot sit back, and I know Charles isn't suggesting this because he knows what's going on. But we can't just sit back and say, I'm not going to do anything because I don't want to participate in this bogus lawsuit. No, if you get sued, you got to participate. You got to defend yourself. And that's true whether it's a car wreck case, a collection case, an employer suing, whatever it is. You've got to defend yourself so that there's not a judgment, because that judgment becomes sort of blessed with, okay, now it is the gospel truth. If there's a judgment, then you do owe that money because the judge says you do. And that can be used to garnish wages, bank accounts, even sell your house. I'm seeing more and more of that, at least in Alabama, where somebody get a judgment maybe for $5,000 and they wait a year or 5 years or 10 years or 18 years. And then they say, now I'm going to take your house. And they do. So definitely defend yourself in these cases. And Charles, appreciate your comment. And I will catch you guys in the next video. Thanks a lot. Bye-bye.